So my name, as you can see from the screen, is Sonali Naik. I'm at Garden Court Chambers, and I'm delighted to introduce this event this evening, which, as you know, is going to address the impact of the COVID pandemic on, particularly on migrants and asylum seekers in the UK. And there are so many areas that we want to cover, which is we're a cross-disciplinary group this evening, both for members of chambers and those who come from outside. We're very, very delighted to have Brian Dikoff from Migrants Organise and Unka Banda from Bindman's Solicitors, and who also from Here for Good, as well as two colleagues in chambers, Danielle Manson and Miranda Butler. And whilst I'm waiting to introduce everybody formally, I just also like to thank Ollie Percy and Abigail Holt, who were also here, who really are the brainchild or the person who fostered this idea to have this seminar and to actually get us together and coordinate the speakers so that we can have this breadth of experience and hopefully then coming together to have some ideas at the end of the seminar. As you'll be familiar with these kind of webinar formats, there's a Q&A function for the questions at the end. I think some people, including Miranda, may have to leave before that, but please do use that Q&A function. So as we go along, and I think I'll take the questions right at the end. And there also is in the chat instructions for participants, both for the panelists and attendees. So hopefully that's where you'll find those instructions. I'll just wait to see whether the numbers are still just going up a little bit. So I'm going to start talking a little bit about our speakers, and then, but I'll wait until it finally admitted everybody before we formally start. So I'm going to ask each of the speakers to speak for about 15 minutes. And that should take us to about 6 o'clock, and then we'll have time for, as I said, for those questions and answers. As we know, migrants are put at greater risk of infection from COVID due to structural inequality in society, to barriers into international travel, disrupting periods of continuous residence. And so the webinar is going to explore the impact of the pandemic from the perspective of both campaigners and lawyers who are all working together to protect migrants' rights. And that's a really important perspective, I think, that we'll learn together from that. And it's a really interesting moment after over a year of being in the pandemic and in this current period of unlocking, which is in some ways quite frightening, to see what will happen next in terms of risk and an impact. So I think we're up to 100. I said, even though it's still going up, I'm going to ask people to start because it's taken 5 minutes to admit 100 people. So I'm going to first of all come to Brian. So Brian Dikoff is the legal organizer from Migrants Organise. His work, he provides advice and casework support for members of for immigration and other welfare issues. In 2017, he founded the Migrants Mental Capacity Advocacy Project, which is a specialised project looking into the issue of mental capacity in the immigration system. And he's done other important policy work, pushing for the litigation friend in that context to obtain ex gratia payments from HMCTS. He also led the recent legal challenge against the Home Office on lack of policy for persons who didn't have mental capacity and how they could access the EU settlement scheme, which actually led to a significant change in amendment to Home Office policy. So he also leads on general strategic legal work in different campaigns, Patients Not Passport and Abolishing Reporting. And so he worked significantly with the Public Law Project and co-authored a report on the lawfulness of the current bail immigration reporting regime. That report funded by the Strategic Legal Fund. And that report led to the creation of the Abolish Reporting campaign. So there's quite a lot I could say about Brian, but I'm going to let him do the talking about himself because he's got a very lengthy and interesting and important CV. But I'll hand you over to Brian. Thank you very much.
Thank you so much, Nali, for that introduction. And thanks so much, everyone, for having me here today. I'm going to try to share my screen now. Hopefully it will work. Great. Can everyone see that? Yeah. All right. Hi, everyone. So my name is Brian. I'm the legal organizer at Migrants Organise. Just a quick introduction for those of you who don't know, Migrants Organise is a charity based in Ladbroke Grove, London. Under our community program, we provide ongoing and holistic support for vulnerable migrants and refugees, and then we combine this with our strategic work and policy campaigning and community organizing, so including our mental capacity project, the Patient Not Passport campaign with MedAct, and also recently the Abolish Reporting campaign with These Walls Must Fall. I've been asked today to talk about our work around immigration reporting during this pandemic. So I thought what I'm going to do today is actually to run through the history of reporting and the work that's been done so far, because as a lot of you here will know, the issue is very much still alive. And then afterwards, I'll just kind of highlight a few different issues, main issues that Migrants Organise and These Walls Must Fall and the campaign are particularly concerned about. Sonali, please let me know if I'm running out of time. I've just keenly realized now that my slides are very long. So in terms of history, I thought it might be interesting for a lot of people here to know that reporting condition is not a new concept. The restriction and condition imposed on migrants have existed at least since the Immigration Act 1971, where the Secretary of State was given the power to set restrictions on migrants, including reporting at police stations. More recently, there was a case of B and the Secretary of State of Home Department. It went up to the Supreme Court in 2018. And the case dealt with the question of where an individual could not lawfully be detained, was there a lawful power to grant bail? And the Supreme Court said no. So I've copy-pasted there the judgment of Lord Lloyd Jones at paragraph 33. He says, however grave the risk of absconding or the risk of serious offending, it ceases to be lawful to detain a person pending deportation. And therefore, there's no longer a power of detention and no longer a power to grant bail under paragraph 22 or 29. So obviously, this did not sit well with the Home Office. They would like to set bail for everyone. So then they introduced via the Immigration Act 2016, Schedule 10, which I'm sure a lot of people here are familiar with, the power to put bail on all migrants who are currently in the system. So individuals who are still through the asylum process system, for example, and who do not have a status yet will be put on immigration bail. And by Immigration Act 2016, they have to be given at least one bail condition. Now, what's interesting to note is that under the legislation itself, there is no preference in terms of which bail condition needs to be imposed. So the legislation itself talks about reporting condition, detention, residency, no study condition, and also importantly, any other condition the Secretary of State deems appropriate. But of course, in practice, what we see is that reporting conditions are used quite a lot. We did an FOI request, and it was revealed that 76.4% of migrants who are on bail are given a reporting condition, even though in 2018, the absconding rate was only 3%. As Sonali indicated, the work at Migrants Organise on reporting condition really started with our report, which evaluated the lawfulness of the current reporting condition. It actually started because of the experience of one of our members who was a very vulnerable victim of trafficking. She suffered a lot of panic attacks when dealing with authority figures, and he would suffer a lot of panic attacks during reporting events. He would come to our office crying, not wanting to go, being really scared. And the Home Office kept on insisting on calling her for reporting, refusing to cancel her reporting condition, and even interviewing her to redocument her during one of her reporting events. And that's really what made us look into reporting condition a little bit more closely. And obviously, as I'm sure none of us here will be surprised, there were a lot of issues with reporting conditions in terms of policy, but also in terms of how it's implemented. And we ourselves at Migrants Organise, we have a lot of members who are reporting, and a lot of the examples of reporting conditions can be quite shocking. We have someone who was an elderly lady with mobility issues, for example, who was asked to report every single day at 8 a.m. This was obviously quite an exceptional case, but still, the fact that it happened showed that there is something, not great about the system. She tried to comply with the reporting condition because it's a criminal offense to abscond. But obviously after, I think about a week or two, she just gave up because it's just really not possible. And we have a lot of these case studies where there is really just a lot of, different gaps and issues with the way the reporting conditions are implemented. And we notice that there's just not a lot of safeguards in terms of protecting those who are particularly vulnerable. And then COVID hit, and it really kind of highlights again how reporting condition is quite unnecessary for a lot of migrants and asylum seekers. So during the initial lockdown around March, the Home Office still insisted that migrants and asylum seekers report at the Home Office and to travel all the way to reporting centers, even though there are only 14 reporting centers all around the country. So some migrants have to travel up to 2 hours or 3 hours to go to the reporting centers. And initially, the Home Office refused to budge because they said that reporting condition is, a very important thing that they have to do. Interestingly, at the same time, we saw a lot of issues with subject access requests. And one of the reasons they said they couldn't provide full documents for subject access requests was because the Home Office didn't have enough capacity in response of the COVID pandemic. Yet they were asking people to report. So you can really see where the Home Office priorities lies there. We immediately sent a pre-action protocol letter. Ollie, who is here today, actually assisted us a lot with that to ask the Home Office to cancel all reporting condition, physical reporting condition during the first lockdown. Luckily, they conceded and it was stopped, which was a great win for us. Unfortunately, during the second lockdown, the Home Office reintroduced again physical reporting and initially includes vulnerable individuals in terms of individuals who need to physically report at reporting centers, which obviously was very inappropriate. So I think when talking about the impact of reporting, we really need to think about it in the wider context of the hostile environment. If you talk to someone and you talk about how migrants need to go to a Home Office reporting center every month, a lot of people might say, oh, that's nothing. You can go once a month while you're claiming your asylum. What's wrong with that? But what is wrong with that is that it is not just that, but rather it's a part of the wider hostile environment where migrants are really isolated and refuse assistance every step of the way. And reporting really becomes kind of like a constant reminder for a lot of people that they are not welcome. So every month they have to go to the Home Office and they get that constant reminder that the government wants them to leave the country. And that is, I think, what is really pernicious about reporting condition. So obviously we're still trying to challenge reporting condition and the use of reporting conditions on migrants. One of the main issues that we've been pressing to the Home Office is really the blanket use of reporting condition, as I mentioned initially. A lot of migrants are being put on reporting condition, even though absconding rate was really low. And really, if you look at the different policies on reporting conditions, it's really unclear how the Home Office is supposed to choose which conditions to impose on migrants under the Immigration Act 2016. And we think that is one of the main sources of the problem. So if you see on the right, in the previous iteration of the Home Office policy, immigration bail policy, these are the 3 aims listed in the policy to kind of assist caseworkers to decide on which bail condition to impose on migrants. And if you look at it, there's a certain circularity to the aim because it talks about how bail policy should enable the Home Office to maintain appropriate levels of contact, but then it also talk about reducing the risk of non-compliance and minimize potential delays in the Home Office becoming aware of any non-compliance. But of course, if we talk about non-compliance, then the less strict condition imposed on migrants, then the higher the rate that the migrant will comply with the condition. So going back to my example of the woman who was asked to report every morning, obviously she can't comply with such a stringent condition, and therefore the Home Office is kind of setting her up to fail. And there's also in the policy, if you look at it, there is no kind of framework to decide on which condition to impose, whether it's reporting or no study or residency condition. There has been a very recent update actually on the bail immigration policy, which I thought was quite interesting. And they added this paragraph, which provided a little bit of guidance, I would think, in terms of what, again, which condition to impose. But still, if you see the policy, it is still very much case by case, condition by condition specific. So if you look at the no study condition, for example, there's a lot of guidance there on when it is appropriate to impose no study condition, but then it doesn't say exactly if no study condition is appropriate, for example, which other condition you're supposed to choose. Another issue that we've noticed is that the Home Office seems to position reporting as a welfare check. So we actually met with Migrants Organise and other key charities in the sector, met with the Home Office enforcement department, and had a discussion about reporting conditions and the use of it. And they seem to position them. Interestingly, they seem to say that reporting that a lot of people actually want to report to the Home Office, and they say that reporting condition is essentially a welfare check to ensure that a lot of people, a lot of vulnerable migrants, are not left alone and can obtain the support that they need. But of course, this ignores the history of reporting itself and the threat of detention, removal, or deportation inherent in reporting itself. Because if you don't report, then there is you'll be considered an absconder. It will affect your immigration application, and it is also a criminal offense. So I think there's an inherent disparity there with positioning reporting condition as a welfare check, and that's something that we're trying to make the Home Office realize, I would say. This was also reflected in their previous approach with the interim guidance to physical reporting. The guidance provides on which individuals are supposed to physically report during COVID. And before a recent challenge by Duncan Lewis, it didn't go to the court because the Home Office settled. They actually included vulnerable individuals, including victims of domestic violence, for example, in the list of individuals who need to go to the Home Office reporting center. But after the challenge, then they've removed that, which was another great win. One of the questions that the campaign at the moment is grappling with is actually, what's the alternative? The Home Office has introduced a pilot recently of telephone reporting. We are not very sure what the ambit of this pilot is or who is going to be involved in this. But I think you can see how telephone reporting has some advantages compared to physical reporting. It's easier for individuals, easier to comply with, and at the same time still allows some individuals to maintain contact with the Home Office. But at the same time, it is also quite worrying because it is the Home Office who's implementing this. And it seems to kind of go in line with this recent trend of just increasing surveillance on migrants. So again, a lot of you might know that the Home Office might track migrants' use of Aspen card from national support, asylum support. And there's also recently the idea that Home Office is going to use GPS monitoring for those with criminal convictions. So the worry there is that telephone reporting is kind of just a stepping stone in terms of just increasing the surveillance generally of migrants and their whereabouts. So we are obviously exploring, challenging this from various different ways. We have the Abolish Reporting campaign with These Walls Must Fall, organizing actions and protests. This happened last week, actually. There were a number of different protests to increase awareness about reporting condition in Leeds, Manchester, Liverpool, Solihull, London, and Bristol. And we are also actively looking into strategic challenges, for example. The issue with the challenge, however, is that it's really easy for the Home Office to back down on individual claimants and just change their reporting conditions. So I think Dr. Lewis also recently tried to bring another challenge, but again, the Home Office backed down on the individual cases, so the case couldn't move forward. Just listed a few variety of things that you can do if you want to get involved. You can obviously join the campaign. You can contact me or these Must calls. If you're an advisor, one of the issues that we've noticed is that a lot of people, a lot of individuals who are being asked to report don't seem to understand that they can challenge a lot of reporting conditions when they're inappropriate. They would only talk to us, for example, as advisors when they are really pressed and can't comply with their reporting condition. So we need help. We encounter a lot of individuals in the campaign, and we need help to help them challenge these inappropriate conditions as much as possible. Greater Manchester Immigration Aid Unit is also doing the research on the impact on reporting on family and children, and you can contact WIFCA. I've put the email there. And join our Fair Immigration Reform Movement Charter, where we demand the end of the hostile environment policy.
That's great. Thank you so much, Brian. And you perfect timing, in fact.
Right.
I wanted the perfect timing for your seminar presentation. I just wanted to, there's a couple of questions that came in, and because we're going to be discussing different topics, I thought maybe it might be useful to just deal with some of the quick questions now.
Sure.
One of them was a specific question, which was about the study condition, which was what's the no study condition.
Yeah.
And then moving on to, well, you've answered some of the questions about the legal challenges in relation to Immigration Act powers, 2016 Act powers. But one of the questions was specifically about proportionality and whether there's been any challenge in relation to that. And I'll come back to you on the third question, and then we can probably move on. Thanks.
Okay. Anything okay? Sorry, no. Just in general, I challenge. I don't, not that I'm aware of. I mean, in individual cases, obviously, if it's a JR, then unreasonableness and proportionality always comes into play. It depends really on the reporting condition itself, and 8 a.m. every day is obviously unreasonable and disproportionate, for example. A lot of the times when we try to challenge reporting conditions, we rely on Equality Act duties as well. So kind of focusing on clients' vulnerabilities and disabilities, which usually, and again, individual challenges are usually successful because it is quite easy for the Home Office to just change the reporting condition on that for that particular individual. The challenge is just kind of the broader systemic challenge to reporting condition itself. I think Garden Court had a challenge on individuals who lack mental capacity to understand reporting condition, but unfortunately, the Home Office settled as well out of court. So again, there was no judgment on that.
Yeah. Do you ever have to go back to if you're given bail by the tribunal, do you go back to the tribunal to vary conditions, or was it always to the Home Office?
As far as I know, the Home Office does have a power to alter what the tribunal sets. But if someone thinks I'm wrong, do let me know. I can't remember if there's like a
there's another question which was perhaps the Home Office inclination to impose reporting conditions as a minimum is inspired by the bail guidance for FTT judges, which is the specific bail guidance, paragraph 34. Consequently, the minimum under the new regime is likely to be a reporting condition. Perhaps the guidance should be reformed, or maybe the target even.
That's a really good point, actually, and we haven't considered that before, so thank you. I think we also thought that it's because of the changes to Schedule 10, so residency condition then gives the Home Office duty to provide accommodation, and obviously the Home Office doesn't want to do that. So instead, they just go to reporting condition.
Yeah. I thought the interesting observation, sorry, I'm just going to take the opportunity because I wasn't aware of it, about the telephone reporting and what's the positives and negatives of that might be an interesting place to explore. But I think I'd better move on because I'll otherwise get caught out for time. So thank you very much indeed, Brian, and I'm going to move on to Danielle. So Danielle Manson, Garden Court Chambers. She came to us in March 2020, and she's an experienced defence counsel in criminal matters dealing with serious violence cases, drugs supply and production, and firearms offences. She's got particular expertise in representing children and young people. She's a member of Justice's Racial Disparity in the Youth Justice System Working Party. And while studying law at university, Danielle managed the Innocence Project, working on a range of criminal appeals and applications to the CCRC. And in recognition of her commitment to that project, she was nominated for the Chancellor's Medal upon graduation, and she still continues to sit on the CCRC Stakeholders Forum. So thank you very much, Danielle, and you're going to speak particularly about the impact on frontline migrant workers and communities of colour. So thank you very much.
Thanks, Sonali. Yes, I am. And I imagine that people listening to that introduction are wondering what I've got to say about migrant workers working during the pandemic. So I'll just set out a little bit of background. And that background is that I was approached by the Migrants' Rights Network, sort of at the height of the pandemic, actually, last year, and asked to do a little bit of remote work for them on no recourse to public funds, a project that they were doing. And after doing that work, they came back to me and they said, look, we've been given some money by the Paul Hamlyn Foundation, and we would like to do a research project that looks at and tries to understand the lived experience of migrant workers who were continuing to work during the pandemic. And would I be interested in project managing that? Now, obviously, my background's in crime. I don't practice in immigration at all. But obviously, at that time, I wasn't really in court a huge amount. And it seemed to me something that was very interesting and quite close to my heart in terms of the BAME community and how they had been treated during the pandemic and the disproportionate impact that COVID was having. So I project managed this small project, as I said, funded by the Paul Hamlyn Foundation. Migrants' Rights Network had already arranged to partner with 3 other organisations. That was the Kanlungan Filipino Consortium, Migrants at Work, and the 3 Million Project. And so I was working alongside key individuals from those organisations. And so what I really wanted to use the next sort of 10, 15 minutes to do was to talk to you all about what the findings were from that research, because we did that, we undertook it last year. I was working on the project from about July through to sort of August, September. The report was published in December, and we had a launch event of the report as well. So I thought perhaps just as interesting background, it would be useful to share what the findings were from that report. So if I start by just outlining the parameters really of what we were looking at, geographically, we were focused on 3 key areas. So we were looking at London, the West Midlands, and the south of England. And that was mainly based on existing networks that Migrants' Rights Network already had, and Kanlungan and Migrants at Work and the 3 Million. So we really wanted to use existing networks to try and disseminate the survey and the questionnaire that we were putting out. We also decided to sort of limit and focus the remit of the research on 4 sort of key areas of employment. So we were looking at the construction industry, health and social care, logistics and delivery, and security. And those areas were identified quite early on in the project as being, I suppose, the key areas that had kept going during the pandemic. So while everyone else, like me, was sitting at home doing zooming into courts up and down the country, those were really the key areas that were continuing to work, and we as a society were sort of heavily reliant on. as I said earlier, we generated a sort of survey, a questionnaire that was disseminated electronically. We tried to use existing networks, but we also used online platforms, social media, and we'd also put together some postcards that were being handed out in hospitals and in shops to security guards and things like that, because we really wanted a spread of information, and that was the purpose of what we were asking people. So really, we wanted to understand the lived experience of frontline workers, but we also wanted to understand how existing structural inequalities had been exacerbated during the pandemic in places of work. So we formulated questions, and those were contained within the survey. And also off the back of the survey, we undertook some case study interviews to really get some qualitative data about what the impact had been. We had 170 responses to the survey, which we were quite pleased about because it was live for about 3 weeks, so a relatively good response, and we were able to undertake 14 case study interviews. And as I said, the report that we wrote was published in December of 2020, and then we had a launch event as well, where we were fortunate enough to ask Nadia Whittome MP to come and speak, as well as some of the frontline workers themselves, who, I mean, they were by far the most interesting people on the panel, I have to say, and they were quite brave actually, and sort of came forward and spoke about what they'd been experiencing over the last sort of 6 months. So that's a little bit of background about the project. I think what I'll use the remaining time to do is to just whiz through the findings. What I can make sure is that a copy of the report is emailed out to everyone who's on this link at the minute, so you'll be able to read for yourself what our findings were. But I mean, the overall headline was that 76% of those people that we spoke to felt that they were putting their health at risk by continuing to work during the pandemic. And that was quite a startling figure. I mean, what we don't have, and I'll concede this at the beginning, is we don't have a comparator looking at white people or British nationals, although a lot of our survey participants were actually British nationals, but we don't have anything like that to compare it to. So I wouldn't be able to say whether that was particularly high or just if across the whole population that's what people were feeling at the time. But 76% felt that they were putting their health at risk by continuing to go to work. So I whizzed through the demographics just so you've got an idea of who we were able to speak to. So 36% were male and 61% female. 21% were British nationals. 22% had indefinite leave to remain. 16% were on restricted visas. 3% were on a dependent visa, and we had a handful of asylum seekers, refugees, and undocumented migrants who completed the survey as well. Quite a large proportion of those who completed the survey were Filipino, and I think that's because we'd obviously partnered with Kanlungan, and so they were able to exploit their existing networks, mainly with healthcare professionals. And then 29% were from the south of England, 46% were from London, and 25% were from the West Midlands. So a goodish spread. We tried to not be London centric in this questionnaire. And then the vast majority, 74% of our respondents were on permanent contracts. So we weren't looking at people on temporary contracts or anything. And when I go on to look at sort of what the lived experience of these survey participants were, you'll probably be quite surprised that they're on permanent contracts because they obviously weren't treated very well. And of those individuals that we spoke to, 53% were without recourse to public funds. And obviously that was that is, and it remains a key factor, I think, when you're looking at how people feel about going to work, whether they feel like they have a choice, whether they feel like putting their life or their health at risk is worth it. If you've got someone who does have access to public funds, I imagine the balancing exercise that they'll undertake will be quite different. So those were our survey demographics. And then just in terms of the headlines, really, I mean, this was quite a stark quote, and this is right at the start of our report. And this was from a Black African security guard who was working in the West Midlands, respondent 108. And he said, "I remember one time I had to work the whole month, and I know it is illegal. Sometimes after a 12-hour shift, I would sleep only 2 hours and go back for another 12-hour shift." So, I mean, that really just sets the background against which some of these people were working. And as I said, 76% felt they were putting their own health at risk. 54% of those who thought that they were putting their own health at risk felt that they were more likely to contract COVID-19 in their line of work. And then, despite those concerns in relation to their own health, 38% of respondents felt that they were concerned that they would lose their job if they didn't go to work. We found that actually the impact, and again, it's not unsurprising, the impact on those without recourse to public funds had been more severe. So 14% of those without recourse to public funds were unable to pay their rent at some stage. And that was compared to 2% of people who did have recourse to public funds. So obviously, clearly, those who have the benefit of the support from the government were not in an invidious position where they were having to choose between keeping themselves safe and being able to keep a roof over their head. Again, just a couple of other headlines. 27% of those surveyed said that they'd experienced overt racist abuse while working during the pandemic. And I think a few more had experienced less overt abuse, sort of indirect discrimination, being given the worst jobs to do, etc. And then of those who had been subject to racist abuse, only 5% were reporting it to a manager and 3% were reporting it to a trade union representative. So I think the feeling that I certainly got as someone who hasn't worked in or with migrants really as part of my professional practice was that we had we have a relatively exploitative system, that when push comes to shove and we're in a time of national crisis, employers will take advantage of the fact that their employees don't have recourse to public funds, won't put in place the appropriate safety measures, and that the employees themselves don't feel empowered enough to really report that and to sort of seek the advice and support that they need. I think I'm coming to a close in terms of what I wanted to say, but I mean, in terms of what the report contains, and as I said, it'd be great for this to be sent out to you guys so that you can have a look. I mean, we asked people in relation to the impact that this situation that they were in, what impact that was having on their mental health. 73% said they'd experienced stress, 63% said they'd experienced anxiety, 43% said they'd experienced low mood. You know, you can imagine in relation to finance, as I said, 54% felt that they couldn't afford not to work. 30% felt that they were worse off financially because of the pandemic, and 8% overall were unable to pay their rent or mortgage at the same time. I mean, the report is just littered with examples of direct, indirect discrimination, employers failing to take the steps that were required to keep this particularly vulnerable group safe. Like I said, overt racism. I mean, a quote just jumping out at me on the screen. So a Black African healthcare worker working in the West Midlands, respondent 121, told us that a white colleague once said to me, "We should not be letting you people in because you are the ones spreading the virus." And these are our workers, these are our key workers that continue to work during the pandemic, and they're being spoken to in that way. 20% of the people we spoke to were concerned about the impact not working would have on their immigration status. 17% felt that their race influenced the way their employer treated them. And what we also had was quite a high proportion of people reporting that they were required to undertake less desirable tasks than their white colleagues. So 19% required to undertake less desirable tasks. So when working on the hospital wards, that was one of the examples that was given, and some of the really horrible cleaning jobs were, and so some of the more unsafe cleaning jobs actually were given to migrant workers. And similarly, 17% were required to work the less desirable shift patterns. Obviously, COVID meant that people really needed to step up, and it was quite clear that there was a discrimination going on there. So I can see you, Sonali. I'm wrapping up.
No, it's fine.
I see you on my screen. As I say, there's so much that I could talk about in terms of what this report contained, what I personally learned as someone who, even though I'm a barrister at Garden Court Chambers, I work in criminal defence, and I wasn't really aware of the entrenched nature of the discrimination and the impact that it was having on, really decent, hardworking people. So I'll make sure that this report is circulated. It's available on the Migrants Right Network website, I should say. And yeah, I hope, without sounding too dull and gloomy, that I've been able to just give you a very brief overview of what the research contained.
Thank you, Danielle. Sorry to interrupt you. I just couldn't message you because I changed device. Fantastically important work. So amazing that actually, in the context of the pandemic, when people were not working, or certain barristers were not in practice, that you could then pick up a different baton and really take it forwards. And that's such an important piece of research that Paul Hamlin commissioned. There was one question about whether members of trade unions were involved, but you also, I noted in your report, said that very few people had reported issues to their trade unions. So I think that seems to be the response to that point. So I'm going to move. The reason I'm moving swiftly on is because I know that Miranda has to go, but if anyone has any other questions for Danielle, we can come back to those at the end. So I just want to move on to Miranda Butler, also from Court Chambers, fantastic junior public law and immigration barrister. I've worked very often with Miranda, and she's absolutely brilliant. And she's going to present a session on protecting former asylum seekers from destitution in the pandemic. And her biography, which is extremely amazing for her call, is hopefully in your pack. So I won't take up time telling you about that, apart from say that it is pretty spectacular. Thank you.
Thank you, Sonali, for that far too generous introduction. And thank you so much, Brian and Danielle, for two fascinating talks. I'm really looking forward to reading that report and looking at Brian's slides more closely. Now I'm going to attempt to make my slides work. Please do give me a shout if they're not. And I'm going to be focusing in typical barrister way on some rather interesting case law from the last year. I appreciate that we have a range of people in the audience. We have some people for whom this will be an area of expertise and huge familiarity, and some people for whom this might be completely new. So I'll attempt to pitch it at a level for everybody. But if you have any specific questions that I don't get to answer during this talk, please do feel free to raise them afterwards, and my email address can always be provided. So I'm going to be talking about the support that has been provided, or has not, in fact, in many cases been provided, for failed asylum seekers who are destitute under Section 4 of the 1999 Act. As I'm sure many of you will be aware, there are specific and limited criteria in which such failed asylum seekers can be provided with both accommodation and financial support. And it's become an area of extensive litigation and extreme concern during the pandemic. I've included on this slide the situations in which individuals should be able to get support. And it will be immediately obvious to anyone reading them that many of them became particularly relevant during the pandemic. For instance, people who were unable to leave the UK or didn't have any viable route of return, in many cases because their countries of origin had closed embassies, closed borders, weren't accepting any flights. But the real source of litigation during the pandemic is the last category that you'll see listed on this slide, which is when does it cause a breach of human rights to refuse financial support and accommodation to a failed asylum seeker in the unique emergency situation of the pandemic. And essentially what happened at the beginning of lockdown 1, if we can think back all that way, is that the Home Office did the very sensible and humane thing, which was to stop discontinuation of Section 4 support for people who no longer met those criteria that I've just referred to on the previous slide. At the end of March, they effectively extended accommodation and financial support for people who otherwise would normally have been had their support stopped and who would have faced eviction from Home Office accommodation. But recognising the real public health risk that would involve, and as part of the broader Everyone In programme, the Home Office agreed not to evict people from the end of March until September 2020, when evictions resumed. You'll see there I've also noted that evictions have resumed again recently in July 2021, and I'll explain the history to that over the next few slides. In practice, there haven't been evictions from Section 4 accommodation between March last year and this month, but we need to focus on those being discontinuations, which is where individuals already had support and were in Home Office accommodation, as opposed to refusals of support for first-time applicants, which have continued effectively unabated throughout the pandemic, often with some really quite horrific outcomes. The first major bit of litigation that challenged the discontinuation support, remember I said that evictions restarted in September last year, was a case called QBB. And that was a case which challenged the restarting of evictions and of discontinuations on the grounds that it was contrary to human rights because of the serious health risk, both for individuals being kicked out onto the street during a pandemic and for the broader community. It was also said to be an irrational policy, in particular because there hadn't been appropriate regard to the public health risks involved. And that challenge was astonishingly and very swiftly successful, with Mr. Justice Fordham granting generic interim relief on the papers, which is very unusual. I'm sure everyone will be aware. Simply on the basis that there was no proper justification for continuing to turf out destitute, failed asylum seekers in the middle of a pandemic. And you'll of course remember in November last year, there were tier restrictions in place, cases were high and rising, and there was at that stage indeed an imminent national lockdown. And that provided a significant degree of protection for failed asylum seekers for many months subsequently, but it only protected those who had already been in accommodation. So as I mentioned previously, we're not talking about people who are outside the system and trying to get in and being refused. It's just people who are within the system who are protected by this order. That approach was also mirrored in the Asylum Support Tribunal in a case called PA and MA that said that in higher risk areas, it was equally unlawful to discontinue support because of the health risks involved. So what about people who had never got into the system? What about people like my client, Mr. EW, who's mentioned on this slide, who was in a psychiatric hospital for basically from the beginning of lockdown. He was released from psychiatric hospital at the beginning of December last year to street homelessness. And he was left without accommodation, without support under Section 4, on the streets in December during a pandemic. It was quite an astonishing failure to protect both him and public health. Unfortunately, these cases were not quite as successful. Whilst Mr. EW was eventually accommodated, the broader challenge that was brought both by my client and by an individual called KMI, no similar success was seen with the application for generic interim relief. There was a short-term mechanism put in place to allow for expedited applications to the High Court, but Mr. Justice Swift wasn't having any of that, unfortunately. And by the time we got to April of this year, he simply directed that any urgent applications challenging refusal of Section 4 support should just go to the High Court like any other urgent application and be dealt with in the conventional way. And so these various challenges were consolidated with a focus on discontinuations only, and were heard in June with a judgment quite shortly thereafter by Mr. Justice Chamberlain, another very excellent, intelligent judge like Mr. Justice Fordham. But unfortunately, he didn't come up with quite as generous an outcome as Mr. Justice Fordham had. He spent a little amount of time reviewing the basis on which human rights obligations can give rise to a positive obligation to provide support and accommodation. And essentially his conclusion was, unless there is unless you're in a situation, for instance, where you can't get into your country, the kind of situation already provided for under Section 4, you're unlikely to be able to demonstrate simply on the basis of COVID risk that you should continue to access accommodation that you'd otherwise be eligible for. And he recognised that there might be individual circumstances which were influenced by COVID that might lead to it being a breach of someone's human rights not to provide them with this accommodation. But he departed from Mr. Justice Fordham's approach of essentially saying you can't start turfing people out onto the streets in the middle of a pandemic. And it's interesting to speculate how different this claim might have been if the judgment had been handed down in December or January, rather than towards the end of the restrictions and with the imminent abandoning of all restrictions whatsoever. So whilst this isn't an encouraging case necessarily, it does remind anyone who's representing vulnerable minors to focus on the individual factors in their case, and to recognise that it may be possible to keep individuals in accommodation where there are meaningful risks to their health and where there are barriers to their return. But unfortunately, it's not going to open floodgates to imposing positive obligations on human rights grounds more broadly. And so following this case, unsurprisingly, the Secretary of State has decided to restart evictions from asylum accommodation where people are no longer eligible for support under Section 4. And however, they, whilst cessations have restarted from the 19th of July, there is a 21-day notice period in place, and accommodation can be extended where an individual needs to self-isolate, which is particularly relevant in light of the so-called pingdemic that we're currently dealing with. It's not going to get us anywhere to be making generic arguments to say that nobody should be being kicked out at the time, but looking at the criteria under the 2005 regulations and looking at Mr. Justice Chamberlain's decision in AM, we should certainly be emphasising the individual issues and barriers for our clients, especially where they're at higher risk of COVID, given the high levels of cases, especially if they're going to have difficulties returning to their home countries. One of the organisations that's been absolutely fantastic throughout this litigation and dealing with all of these issues is ASAP, the Asylum Support Appeals Project that many of you will be aware of. They have done brilliant work, and if you have any questions really about anything I'm talking about, just go onto their website and they have really helpful, clear explainers about what's going on and what the situation is today. So that's a whirlwind tour through what's happened with support for destitute failed asylum seekers over the last year, and it's a little bit of a sad story. So I'm going to give you a slightly happier one, but one that isn't directly concerned with Section 4, although it does involve an individual who eventually was accommodated under Section 4. It's a High Court case called Incubate, in which the court accepted that local authorities do have powers in emergencies, both under the Local Government Act and under the National Health Service Act, to provide accommodation in emergencies such as the pandemic, provided that they're not trying to undermine the provisions within the Housing Act. And so it was held that as part of the Everyone In programme, it was lawful for local authorities to act outside their traditional Housing Act powers to provide accommodation, provided that that was specifically aimed at protecting public health and dealing appropriately with a national emergency. I think some people have perhaps read this judgment as indicating an exciting new way of getting around some of the strictures of the Housing Act. I'll leave it to my much better versed housing team colleagues to tell you whether that's right or not, but it's certainly worth bearing in mind as COVID continues to cause issues, and in any other emergency situations such as local flooding that we've seen lately, that local authorities do have these broader powers. No, that's everything I want to say. Thank you very much for hanging with me as I talk about my favorite pet subject, namely asylum support. And I'm going to hand back to Sonali now.
Thank you very much, Miranda. That was really interesting, and just bringing us sort of up to date. I think the point you make about the timing of those generic injunction cases is critical, as you pointed out. You get the interim relief. If the hearing had been at the time, the substantive, then we might have had a very different decision. But these cases certainly have a wider political context, even if the judgments aren't supposed to be overtly political.
Certainly.
I can't see any other questions specifically. Oh, in Incubate, one question was from Richard Williams. At what point does the exceptional context of the pandemic end? Well,
I think that's the $1 million question, isn't it? I think it would all be context specific. I think if a local authority turned around today and said, we've got rising cases in our borough, it's specifically linked to this homeless population that we have data to believe is causing a faster spread of particularly the Delta variant, and therefore we're going to use these exceptional powers, and we've properly thought about our Housing Act powers and we're not trying to circumvent them, we're just trying to protect public health. Potentially you could get away with that, I think, and I think it would all come down to the relevant authority's ability to show a kind of good faith explanation as to why they considered this was an appropriate use of their emergency powers and what the health and emergency risks in the area were.
Yeah, that's really, thank you. I'll just check the other. Is it possible, yes, to receive links to the organisations mentioned throughout the session? So that's sort of to the, for example, Asylum Appeals Support Project, Asylum Support Appeals Project, I should say, and so on. So we'll try to get those sent out, as well as to the links that Danielle's report from the Migrants Rights Network, which I've looked up just now, and it's very interesting. So we will try and sort that out during the course of the session, and if not during the course, then it will be we've got the participant list and you get the slides, so that should be something we should be able to manage. But there we are, Miranda's put that into the chat. Thank you very much, Miranda. I know you can't stay, so I'm going to thank you and
thank you, everyone.
Evening, and without more ado, move on to our final speaker, which I'm very excited to hear from. So we have Unka Banda from, as I said, from Bindman's, immigration solicitor from Bindman's and Here for Good. Unka's work focuses on her work arising from the firm's partnership with that organisation, specifically providing free legal advice to vulnerable EEA nationals and their families affected by Brexit. And so that's the focus of her current practice, particularly the EU settlement scheme. And that is what she's going to talk about, on the impact of the pandemic on the operation and of that, an application of that scheme. So thank you very much, Unka.
Thanks, Sonali. Let me just try and get the slides up, and then I will begin. Okay. Great. Yeah, thank you. So I'm going to be speaking about the impact of the pandemic on the EU settlement scheme. And I think, I'm sure as most of you will be aware, there have been a number of ways that the pandemic has really impacted the work that a lot of us have been doing under the EU settlement scheme. Today, for ease, I'll just focus mostly on some of the more substantive issues to do with absences and how we've dealt with the guidance. But I think more broadly, there have been a lot of, I mean, the EU settlement scheme itself has a number of issues, generally speaking. And a lot of these issues, I think, have been made worse by the pandemic. So for instance, the process is quite digital, which has meant that there have been a lot of technical issues happening during the pandemic, from the online status website breaking down to issues accessing the actual application itself, not being able to get through to the resolution center, which has caused a lot of people a lot of distress, and has made it quite hard for those of us that are also advising people to be able to do the work. Also, we found that there have been a lot of difficulties in terms of assisting vulnerable clients, especially clients who are homeless or those that have mental health issues, because it's much harder during the pandemic to be able to find ways to maintain contact with them. And also another aspect of, quite broadly, is there have been a lot of changes that have happened to the EU settlement scheme during the pandemic, especially in the few weeks leading up to the deadline on the 30th of June. So these have ranged from the Home Office emailing certain groups to say, okay, we're now going to be accepting these kind of emails via this particular way. Paper applications being put on their website in dribs and drabs. So one day there's one application, the next day all of them are available, but there's nothing more widely actually. People in general were not actually notified of these things, and all of us really had to rely on others to notice these things and spread the word on what was going on. And I think probably the most distressing update that we all received was on the day of the deadline, the system crashed because so many people were trying to access it. And I think it was around 11 p.m., about an hour before the deadline actually was due to happen, the Home Office decided to tweet to basically tell people that actually, if you've had any technical issues because the website's broken down, whatever, we will accept your application as being on time if it's received by 9 a.m. But obviously not everyone is going to be doom scrolling at 11 p.m. on the day of the deadline. So, and that isn't something that was really spread much more widely, which is very, very problematic. Sorry, my screen has now been a bit weird. Okay, so in terms of a bit of a timeline about how some of the key dates have impacted the work under the EUSS, I think the key dates really to keep in mind are that on the 23rd of March was when we went into the first lockdown, and the first guidance that the Home Office published in regards to how absences that were, COVID absences would be taken under the scheme was published on the 15th of December, which is, quite a long time after the lockdown started. And actually there were other guidances that were published much quicker for other routes under like the immigration rules and stuff. And one thing that is really quite problematic is the fact that the guidance was published on the 15th of December, and on the 31st of December, a mere 2 weeks later, was actually the end of the transition period, which meant that people didn't really have much time to be able to rectify any, to be able to come back if they were abroad and so on, or to do anything about the situation that they would be put into by that guidance. So given this, Here for Good, in conjunction with Bindmans, basically decided to bring a legal challenge. So I will come on to speak about that in a second. But I think it might also be helpful to just give some background to the EUSS, just so that everyone, including people who don't necessarily work in this line of work, actually understand what I'm talking about. So continuous residence is a really important factor in eligibility under the EU settlement scheme. Under this scheme, you can get two statuses. One of them is limited leave to remain, which is more commonly known as pre-settled status. And that's given to you if you have a continuous qualifying period of under 5 years. And the other is indefinite leave to remain, which is more commonly known as settled status, which is granted if you have a continuous qualifying period of 5 years. So in terms of the definition of continuous qualifying period, that is defined as being, so when someone has started their residence before 11 p.m. on the 31st of December 2020, and that period has not been broken under certain circumstances. So the breaks under the law now, the breaks that would be allowed are up to 6 months is fine, between 6 months and 12 months for an important reason. And the important reasons are quite limited. So it's for if you're pregnant, but this is specified within the law. And I think it's it's important to keep in mind that there are quite severe consequences to basically exceeding the absences. So it could lead to a person losing their status. For example, pre-settled status can be lost if you're outside of the UK for 2 years. And settled status can be lost if you're outside for 5 years. And then another consequence would be not qualifying for settled status if your absences exceed what is allowed. So as I mentioned before, pre-settled status is granted for a period of 5 years. So if your absences within those 5 years exceed what is allowed in law, then you technically wouldn't qualify for settled status. So moving on to the EUS's guidance that came out on the 15th of December, the government basically accepted that, yes, the pandemic has been quite difficult and there are circumstances which will lead people to falling outside of what is already allowed in terms of absences. So they decided to come up to expand that a little bit to allow certain situations. So as before, an absence of up to 6 months is fine. It won't break your continuous qualifying period. And then moving on to the second category, so an absence of between 6 and 12 months during a 5-year continuous period will be okay if it's linked to specific reasons to do with COVID pandemic. So the first one was if you yourself are unwell because of COVID-19, if you're a student in the UK but happen to be overseas because of the pandemic, or if you're self-isolating. And even within self-isolating, you had to fulfill a particular criteria where either you've been unwell, or you're living with someone who is unwell, or you've come into contact with someone who is vulnerable. One thing that the guidance did, though, was to say that they will stick to the restrictions in terms of absences of more than 12 months, and that if you are outside of the UK for more than 12 months, that will continue. Their position is that will still break your continuous qualifying period. And also the same position in regards to having more than one absence. So as I mentioned before, so Here for Good started receiving a number of referrals for people that were absent for a number of different reasons, not covered by the guidance, but related to the pandemic. So we found that there was quite a lot of issues with the guidance that were published on the 15th of December. Firstly, that the policy was quite restrictive. It didn't account for all the situations that people would find themselves in. Another is that it really conflicted with a very clear and consistent messaging regarding public health and what the government was saying to people in terms of protecting themselves and those around them. And another issue, which I've already mentioned, was that the guidance itself was published very close to the end of the transition period on the 31st of December, which meant that people who were caught out by this essentially had 2 weeks to return and to start their period of residence again, or face the consequence of basically no longer qualifying, which is quite a horrible position for someone to be put into. So if we could basically brought the challenge and made a number of different arguments raising these issues. And these arguments included basically saying, well, it's really not, the guidance itself has failed to consider a lot of different inevitable consequences of the pandemic and has put people into a really unfair position. It's penalized a lot of individuals, especially those that are quite vulnerable to the pandemic, in terms of penalizing them for having to follow government advice or travel disruptions, and then also that it has a disproportionate impact on a number of vulnerable groups. So the original guidance, the one published on the 15th of December, was withdrawn in May, and a new one was published on the 10th of June, about 2 weeks after they said that they would publish it. But the new guidance is quite generous and really quite helpful. And I've just set out quite broadly some of the key factors to consider. I'm happy to send around a link to an article that I've written for ILPA, which has a bit more information in terms of like what the different criteria is for each of those scenarios mentioned, so that it gives you a bit more of a background. So basically, the revised guidance is has been said to be an interim measure whilst they actually amend the Appendix EU itself. And it accepts that there are a number of circumstances due to COVID-19 where people are absent for longer than is actually permitted under the appendix. So I've split the circumstances into 4 scenarios, where the first one is your intention was to be away for 6 months, but exceeded that up to 12 months, where this is again fine, and that COVID-related reasons will be considered under the important reasons, which are allowed under the appendix itself. And they've now taken an approach to say that we're not going to give an exhaustive list of what will be allowed, as long as you can basically make an argument for this, and as long as you can show some evidence of the circumstances, it should be okay. Absences for up to 12 months, I've kind of covered this as well. And then I think quite interestingly, they have also allowed absences that exceed 12 months for an important reason, but where you have been advised against or prevented from returning. So this is a bit more generous, well, much more generous than the first guidance, but I think it's very important to keep in mind that even though you can be outside of the UK for more than 12 months, you really have to show that you are advised against or prevented from returning, which is, not quite as generous as one would expect it. But again, as long as you can show that that particular factor is present, then you should be able to argue and rely on the guidance itself. And it also allows for more than one absence, where one of them was up to 12 months and for an important reason. I think it's important to keep in mind that where your absences exceed 12 months, there's also a slight change in terms of how this will be dealt with in terms of your continuous qualifying period. So for example, if someone is, if you've left the UK for, let's say, 18 months from the 1st of January 2020 and came back the 1st of June 2021, sorry if my maths is off. So you can basically rely on this guidance and say, okay, I was absent for more than 12 months for an important reason because I was advised against or prevented from returning. And this should be okay in terms of explaining your absence. But in terms of you qualifying for settled status, what will happen is that the first 12 months of your absence will be counted as part of your continuous qualifying period. And then the last 6 months, effectively your residence is paused until you come back. So you can't rely on the 6 months, let's say from January until June 2021 as part of your residence. So essentially what you have to do is when you come back, when your pre-settled status expires after the 5 years, you will then have to apply for pre-settled status again, make up the 6 months that are not included, and then after that period, apply for settled status. Also really interestingly is that the guidance now also allows, also includes people who have been absent for more than 2 years and have therefore lost their pre-settled status due to this. So people in that category would be able to apply for pre-settled status again from abroad and then be able to come back. Sorry, I'm not sure what I meant by the second point. We'll just move on. I think there are still a number of issues that have been raised in terms of like absences and the EU settlement scheme. And more broadly, they fall into basically just saying that really and truly there should be more flexibility in terms of absences under this scheme, because that will help a lot of people, especially because right now, even though we do have this COVID concession, the reality is that if it's not related to COVID, you still have to fall into the like exhaustive list of important reasons, which are quite limited. Right, so that's everything that I had to say. Let me know if anyone has any questions, but thank you very much for having me.
Sorry, my apologies. Thank you very much, Unka. That was really, it is so interesting to see what the impact of the way in which you have a scheme that's could have been set up, could have taken 3 years to set up a scheme, and you're still getting down to the situation on the last day, at the last hour, with very vulnerable people being plunged into total uncertainty and chaos in some circumstances. I think flexibility is obviously the name of the game, and that's something that we really struggle with in immigration during the course of my sort of experience, because in the past there was always a lot of flexibility within the policy structures. Individual case owners knew that they had flexibility to exercise discretion, and now because of this sort of focus on rules, you must meet the points, you must meet the requirements. I think there's a real lack of understanding in the Home Office as to how flexibility can or should be exercised and what the parameters of it are. And then it leads to more litigation, and that people then don't have remedies. And that's really back to, why is there so many appeals or so many judicial reviews? Then why is there so much litigation? Because there's such huge uncertainty and no other remedy for people who are in those circumstances. So really important to hear from you on that. Just got a question from Mel Steele, not related to absences, but any thoughts, she asks, on whether it's possible to challenge a suspiciously huge number, approximately 50% of EU SS decisions of grants of pre-settled status, rather than settled status, with all the ongoing precariousness and likely cliff edge, both in terms of status and access to benefit, and if the Supreme Court Frotilla judgment is unhelpful, or whether these challenges would have to be on a case-by-case basis. Do you want to come back to that one? And there's quite a few questions I'll come back to that.
Sure. Yeah, so I think it's very difficult to say quite broadly that all of them can be challenged, because I think it really depends on the circumstances of each case. Yeah, because I think if someone applied for settled status and you provided enough evidence for them to be granted this, or for example there was someone who was quite vulnerable, or for instance homeless, I found that with homeless clients they tend to lack a lot of documentation, so we have to rely on basically making representations explain their circumstances. And then if the Home Office then come back and say, no, we're just going to give them pre-settled status, then maybe a consideration can be made as to challenging that. But I think it's quite hard to just say broadly that everyone who's been granted pre-settled status should challenge it. But obviously I completely share your concerns in regards to how insecure having pre-settled status is. And the reality is that for a lot of people, especially the people that my organization tends to work with, who would struggle really and truly to remember when their pre-settled status is going to run out. And already I'm having clients coming to me saying they've lost access to their emails, their phone, everything, like they can't even get in to be able to show anyone who asks them what their status is. It's a very difficult system to navigate. But I think I am, as sad as the whole scheme is, I do draw some hope from the fact that like quite a number of organizations are actually trying to challenge different aspects of this. For instance, there was a challenge recently about the fact that there's a digital status, which I imagine now that we're actually post the deadline should come back again and so on. So I think in short, I would basically recommend that if anyone thinks that a grant of pre-settled status is not quite right for whatever reasons, and I would say, yeah, consider whether there are grounds for challenging this, or trying to get someone else, for instance, at Here for Good or wherever else, to consider what their legal position would be. Something that I didn't mention actually, but yeah, Here for Good are going to continue taking on referrals going forward. So we're more than happy for people to forward us anything that they want us to have a look at in terms of complex cases, or just to, check things like that as well.
I mean, it strikes me that, thank you so much for that. I'll come a couple more questions for you, but it strikes me that in answer to the sort of wider, broader challenge, it may be that once there's a body of evidence that's built up about who's in that pre-settled status category and why, maybe in answer to FOIs and other sort of PQs, getting some disclosure or some research, that might be able to build a case there. Two other quick, well, maybe not that quick questions. Have you been successful in arguing that someone wasn't able to begin being resident in the UK before the 31st because of December 2020 because of COVID? Because the COVID travel guidance advised against it. For example, EU nationals who wouldn't have realised the transition period applied to their child, for example.
Yeah, so we've had a few referrals that asked this question, and I personally have not made any applications on this basis. And my understanding is that there really isn't much flexibility on this from the Home Office's side. If you were not resident in the UK by 11 p.m. on the 31st of December, you essentially don't have a way in to the EUSS. Sorry, this is specifically for obviously the EU nationals, EUSS. Yeah, family members who are outside and had their relationship already existing by that time could. But yeah, if we're talking about EU nationals who weren't resident by that specific time and date, because of COVID, the guidance doesn't really give you a way in, unfortunately. I mean, I'm more than happy to be corrected if that is wrong, but that's my understanding.
No, I don't think I certainly don't know any other answer than that. So thank you very much. And a final question before I just want to come back to Danielle because I cut her short before in terms of Q&A. Is the settlement scheme EUSS applicable to persons who want to apply via Zambrano from outside the UK for applications brought after the 31st of July 2021?
Oh, Zambrano cases are in like a specific category of their own. So I know that there's a completely different deadline for Zambrano cases. So the 30th of June wasn't for them. But in terms of specifics, if that person can just drop me an email, I can come back to you with more information, because I would need to double check about them applying from abroad, because I haven't really dealt with that.
Okay, yeah, I think thank you so much. I don't know if there are any other questions, but thank you for Danielle's. What Danielle has done is posted into the chat the links to the various organisations that she worked with within the MRN report, the Paul Hamlin report, and I've just been looking briefly at it whilst with one eye, not having looked at it since the original launch, and it's interesting that there's a sort of theme coming back from the whole event that we've had today, which was one of the recommendations, of course, was to abolish NRPF conditions. Now we've just heard sort of succinctly but acutely the impact of the NRPF. Another recommendation was to review the effects of the hostile environment, and as well as then the more specific things about increasing national minimum wage, statutory sick pay, and obligations on employers about whether they've what accountability mechanisms that they have. But in the context particularly of NRPF, of course, we've had the judgment from the divisional court in the W case about whether it's compatible with Section 55 obligations, and the government's whole approach to waiting for people to become destitute before they will then allow them to get a remedy, which sort of feeds into Miranda's presentation. So I just wanted to know, Daniel, whether you had any final observations on what you've heard, because it seems to me that your report spans so many things that we've heard about from Brian, from Unka, from Miranda, and as I say, it couldn't be more important to have that sort of overview. But I just wondered if there's anything else you wanted to wrap up with. But I thought I've come to you as a final wrap up person.
Thank you, Sonali. No, I suppose what I'm disappointed with myself about is that I consider myself to be relatively educated. I'm a member of Garden Court Chambers. I share the ethos, do right, fear no one. And I, working in the criminal justice system, just had no idea how awful it is. And we hear, people talking about the hostile environment, and, Windrush in particular sort of affects members of my family. But I feel a little bit ashamed, actually, that I've been so blinkered to these issues. And I suppose really my work on the project and what I'm going to sort of undertake to do moving forward is to just ensure that I'm having dialogue with other people. I mean, there is a bit of an overlap between the criminal justice system and the immigration system, but not really in terms of migrants working and being exploited and things like that. So I think that really what I need to do is ensure that I'm having conversations with people so they understand the reality of it, just on a human level, not on an academic level, not discussing a recent judgment perhaps, but just trying to bring to people's attention the fact that, your neighbour or someone you sit next to on the tube, or, someone serving you at a restaurant or at a shop really could be facing the most insurmountable challenges at the minute, and it's not something that sits well with me. So I suppose really drawing all the threads together, that's what I'd say, and that's what I can do on a human level, not being a lawyer but just being a person. So
I think that's a really important and brilliant place to end this seminar, because it shows the importance of campaigners and lawyers coming together as human rights activists and human beings, and to make sure that we share the experience, that we're not sort of siloed and marginalised even in our own practices or communities, and that people understand the impact of government policy on very particular and exceptionally vulnerable groups in our society, and that, you know, in the name of, I don't know, some sort of in the name of governance, I don't know what it's in the name of, but in the name of some hostile right-wing agenda or populism, I don't know which of those things it is, but it's got to be informed, and people must understand that the real and true impact of those policies. So this event's really important. The report, fantastically important. So brilliant to have Brian and Unka today, just to give us that depth of understanding, because you deal with people on the front line. We're dealing with people on the next line backwards, counsel in court quite often, but you're right there on the front line. So thank you so much, and I hope we've answered most of the questions, if not all. I know there's one or two more, but please, we just wanted to try to finish on time. So thank you everybody for coming, and thank you for participating. Thank you.
Thanks so much, everyone.
You can't hear us clapping, but we are clapping.
Thank you.